All right. Are we live?
We are live.
Oh, all right. There we go. See it. My screens get all kind of confused. And hi, this is Kurt Varone, and welcome to
And
another
Brad
edition
Pinsky.
of File or Roundup for November 4th of 2024.
Day before the election when all
Happy
hell breaks loose.
and happy, yeah, I know it. And happy November. Happy November. So
That's
here we
right.
go. Brad, go ahead. Take us
All right,
away.
let's start in Ohio. There's two ways to do this one, and you'll have to tell me what you think. We could cut to the chase or we go through the facts, but I'll do my best. The holding's not hard, but let me pair out the issue for everybody. So here we have a opening in the fire chief position. We have an appointment which was made provisionally, and then someone else actually gets the permanent appointment. So as you can imagine, the individual who wants the permanent position and didn't get it challenges. And there's a number of questions here. So in the end, let me jump to the end and we'll see how we got there. In the end, the court holds, listen, the person who's appointed permanently is the permanent person who's going to hold the fire chief position. And the temporary person, they say, should have had no expectation of being permanent in the interim provisional appointment. I don't think this is a revolutionary holding, but how they got there is certainly interesting.
Yeah, and it shows the complexity sometimes when you have some state law, you have the city charter, you have court decisions, and you're trying to figure out, did somebody inadvertently get the full-time chief's job? Because it's pretty clearly says, I think it's the charter, pretty clearly says that once someone is promoted to the rank of chief, they can only be removed for cause.
Right. But the court held that the interim appointment doesn't qualify for that protection.
The law didn't say that. So it's interesting. I thought it was, but at any rate, go ahead.
And not to get so fact specific, but because it goes on for 3 pages, but the court looks at a lot of different factors for a couple of different questions. So for example, they looked at, there was a test, right? And who scored the highest, who scored the lowest. And isn't it interesting who scored the highest and the lowest? So the chief who challenged this, who had the interim appointment, scored the lowest. And
but he was also the senior. He was
senior, though, right?
Assistant chief of department. I believe the other firefighter was a lieutenant. So now you've got and just the cultural parts of that, where you're the assistant chief and now you see a lieutenant going past you to become your boss.
Yep. And so the major part of the decision is who's the permanent appointment, or right? And who should have been, and was there an expectation about the interim that they would become the permanent? But then there was another factor, which I thought was interesting in here, which was the test itself. The test had some interview, some assessment section to it. The union actually agrees that, saying you can't do that for this. The whole thing, the whole appointment is kind of a mess. And right. I'm sure there have been cases. I've never seen a provisional appointment sue saying, well, I had the right to be permanent. There may be cases. I just haven't seen it.
And I think there's a couple of things here. Number one, they had a set process for how someone would become a chief. And apparently there was something in the collective bargaining agreement that governed that. Okay, so you have this collective bargaining agreement says this is the process. The city then decides, we're not going to do that. And we're not going to negotiate it, and we're going to implement it. The union puts the kibosh on that, and the court agrees with them. The court agrees that you have to bargain this. You can't unilaterally do it. In the interim, how long do you wait? So now the mayor appoints the chief and says apparently verbally says you're going to be the interim chief, but also at the same time when they swore him in, they swore him in as the fire chief, not as the interim chief. Right. And again, he's trying to argue, just like you argue what's going to benefit your where you're sitting, right? My former captain, one of my training chiefs, training officers, later became the fire chief, had a saying: "You shoot from where you sit." Okay, now he was talking firefighter, but I think it's the same issue with legalities. you shoot from where you're sitting. He's going to argue that you didn't swear me in as the interim chief. You swore me in as the fire chief. Given the fact that the union was suing, the union had an unfair labor practice complaint. This could have taken years and so on. You put me in there, and the law says you can't remove me without some sort of just cause, and you have no just cause.
Right.
So.
And so, you know, I hate the new phones. New phones today don't have an off switch to turn the ringer off. Where'd that go? Why'd they get rid of it? Okay. So, you know, and this is mostly a fact-based case, or there's some that are law cases. There's some where there's a question of fact, and it's fact-based. Here, it's mostly a fact-based case, in my opinion, and because the judge is really evaluating whether the temporary fire chief, the interim fire chief, had an expectation that they would be permanent. And really, it almost could have been a jury question if this type of thing went to a jury, but the judge kept it, and you know.
Yeah, no, I think it's I think there's certainly there's a factual basis, but I think at the end of the day, it's really about whether or not someone who is intended to be by the city, not by the member, it's not what they understood, but it's what the city understood the position to be. And, you know, it was a provisional. It wasn't intended to be a permanent promotion.
And even that had an interesting twist to it, factual twist, which is, well, the original language of his oath of office when he swore in as interim had interim provisional in it. That was removed allegedly because civil service told him to remove it. So the intent was to have it provisional. Or somebody could argue you removed it. The intent was to have it permanent. And so they had to explain away why was it in the original swearing in oath, but it never made it into what he actually took. All these things are just how judges try to view the facts.
Yeah.
So, all right. You know, because we can't leave Ohio. And this is a kind of a quick one, but we have another Ohio case where an individual who's pregnant sued a department and two departments, and they're keeping the lawsuit separate, effectively saying they're separate questions. What you have to prove against, you could win against one and lose against the other, so they had to be separate lawsuits. I mean, that's basically what goes, you know, that's the legal holding. The factual holding, or the factual allegations are very interesting. And, you know, let me pull a couple out. So she was pregnant sometime in late 22. Her allegations is that both of the departments began discriminating against her after they learned she was pregnant. And here, the facts kind of match up, if true, right? The facts get her over some hurdles here, if she had any. She said she alleges she was instructed by her supervisor. This is at one of the departments, PTFD. She was instructed to look for a new job. She requested a medical leave, but was asked to provide paperwork from her doctor. Under some laws, that's okay, and some it's not, frankly. I do have one thing I want to ask, however. So, and then she was placed on unpaid medical leave. She was not offered light duty assignments, despite the fact that others were. So that's at the PTFD. At the BTFD, she was given light duty. Technically, I don't think this is really light duty. She was just assigned to a driving position as an accommodation. But then she says when people learned about her pregnancy, she's removed from the roster. She had to prove her medical clearance, and she was eventually terminated. So they go through that. One of my questions is how she's proceeding. You know, under the ADA, pregnancy is not a disability, right? Under other laws, it's protected, but under the ADA, it's not. So I was trying to see I mean, I know she has some whistleblower stuff or whatever, but what are all of her
Title
claims?
VII. I believe it's Title VII, gender discrimination.
And why not pregnancy?
And pregnancy discrimination.
Yeah, that's what it should be, just not under the ADA.
Yeah,
and family medical leave, once again, they miss.
Yeah, I don't think she alleged a disability. Yes, I know. I was waiting for that. And that would be?
Family medical leave retaliation would have been a great suit. It would have been a great suit. And lawyers, as we always say it, just miss it. And some of the things
complicated. The FMLA, you know the FMLA. You know it inside and out. But a lot of attorneys don't. And if it's one of those areas where you don't practice in, you might miss the issue. And I think strategically, sometimes attorneys want to narrow the issue. So you're not shotgun pleading, you're going after like your strongest argument only.
Yeah.
Uh,
Yeah.
but
And look, under FMLA versus some others, when somebody says you have to get evaluated by a physician, under FMLA, it's your own physician who has the right to evaluate you and clear you. Under other statutes, right? Whether you can meet the job performance requirements, it may be the department's physician. So, maybe they strategically said they didn't want to do that because it gives the department a little, hey, we said we said your own doctor has to clear you, FMLA, whatever. Who knows? But when you have let's talk about what should be done. We're not saying what happened. We don't know, right? We just have allegations here. But what should happen when you have a pregnant employee, remember, the pregnant employee determines when they leave the job, if at all, so long as they can meet the job performance requirements. So if you don't have job performance requirements, if you don't have something that says, listen, you have to be able to lift 150 pounds by yourself to waist height or something like that, then how do you send somebody to their doctor and say, doctor, can they do this job? Right? So if you don't have job performance requirements right off the bat, you probably are losing on the department side. If you do have them, then every employee, pregnant or not, has to be able to perform those at all times. And you better make sure you hold one person to the fire, everybody else is held to that same fire. They all can do that same lifting, climbing, whatever requirement. So when you are approached by an pregnant employee, the answer is you tell us when you can't do the job. Now, there's always practical questions I get, right? Which is, what if they can't fit in their turnout gear? Well, if they can't fit in their turnout gear,
get them new turnout gear.
Right, which will arrive, 3 months after delivery of the baby. But you should at least be looking to see if you can accommodate turnout gear. I thought the department that reassigned her to a driving position as an accommodation was good intent, but bad execution, if that's true. Because again, why can't she be an interior? Who pulled herself out as an interior? If she didn't ask for the accommodation, then why are we reassigning her as opposed to you're deciding for her? And if your comment, because I get this all the time when I speak about this, oh, we're protecting the baby. That's not your job. That's the mother's discretion to protect the baby. Look, do I think we might educate women on what the dangers are of firefighting? And by the way, here's what it is. So the women in fire, or iFire, what the organization was called at the time. And I had this woman in my class who did the study at FDIC. She spoke up. They did a study and they found what's dangerous to the baby is not what everybody thinks. It's not, the flames, the gases. It's none of that. It's the heat that we build up in our turnout gear, and you literally can cook the baby's brain, the fetus's brain, causing brain damage, etc. It's the heat. So here's the interesting thing. So when you try to accommodate somebody, if your drivers are still required to wear turnout gear, yeah, maybe they're not as active, maybe they are carrying ladders, but you're not doing the baby any favor. So the department's perhaps ignorance of what the danger is in firefighting to the female and trying to make an accommodation that wasn't asked for. Maybe it was asked for. I'm not sure I know. But you got to make sure the accommodation makes sense. Placing the baby, if you're trying to protect the baby, again, not your job, but you've got to protect the woman. Well, what are the job performance requirements for the driver? What are they for the interior? And who said she can't? Again, I get back to who said she can't do the job as an interior. It better be her physician who said it, not you who thinks that they can't do the job. Anyway, I looked at this case as a good example, if it's true, of how not to handle a pregnant female, if it's true.
It didn't really, I don't think it got into who made that determination, but I think it's a good reminder to folks out there that it's really up to the woman. And there's an interesting case. It was the Supreme Court case. I forget all the specifics, but it involved the battery plant, as I recall, and toxic chemicals. And they would only allow women who could not become pregnant to work in that area because they were concerned that there could be some sort of contamination and so on. So the company was trying
good intent,
good intent, but poor execution in that you can't, you can educate, and that's what we should do. We should educate.
Right.
And you've got low oxygen concerns, you've got CO concerns, okay? But
Exhaustion,
exhaustion, but the bigger one, and strains and stuff like that. But the
the
bigger
female.
one, as you point out, is overheating. And I mean, you just don't go to fires with our modern turnout gear. You don't go to fires and not overheat. I mean, it's
Right.
almost inevitable, but it's got to be up to her and her physician to make that decision. So
Exactly.
yeah, interesting. I thought it was interesting, just the separation. I kind of put the criteria in there to separate a lawsuit. She sued both departments in the same suit, and really there's some factual differences in terms of the way that she was treated by each department. So I thought that was interesting how the court approached it. But something that she alluded to, I don't believe I saw it as an allegation. But what if in a similar suit, there was an allegation of a conspiracy between the two chiefs? Okay.
Then you would tie them together because it would be the same basic factual conclusion. That would be a great, and if they're listening, they're probably like, oh, I'm going to amend.
Yeah. No, well, I think they would have probably argued that if they had a factual basis for that.
Right.
So, but at any rate, I think that would have been one thing that could have kept it together. But other than that, they're really how you're treated by Fire Department A, how you're treated by Fire Department B, and so on. So again, this is one of those we call. I have a category in the database for two-hatters. This is a two-hatter case. Sometimes it's career and volunteer. In this case, it's two paid. I'm assuming she's part-time with both of those
I would assume so.
departments and so on. So, yeah.
And just one more point on this. I had one client who said, well, we're going to require the pregnant female to do a mandatory education on why it's dangerous. And I said, you can't do that. If you want to educate the entire department on general dangers of firefighting and have a section on if you're pregnant, here's one of the dangers, no problem. But you can't tell a female, we're going to educate you on your specific concerns. You want to have a nice conversation. Sure.
In that regard, what do you think about handing out a pamphlet?
I think it's great.
Yeah, I think that's, but again, so you've got to take a class or you've got to go to this. You're going to be the only one in this class. That'd be
right. And look, there's nothing wrong with the fire chief saying, listen, this doesn't affect you in any way, but you might want to look at this article, right? Just letting you know, we're not making a decision, but the reason we're concerned is because of this article we read. You do what you want.
Yeah.
I think it's okay. Yeah. Okay, let's go to Indy. Let's go to Indianapolis. I love this suit. This is great. I mean, so here's what we got.
I'm doing a class and we're going to cover this on Wednesday, just on social media policies. And unfortunately, some departments haven't gotten the memo on the First Amendment, and possibly not so much in Indy, but in a collective bargaining environment, you've got concerted activities concerns. But go ahead.
Yeah, well, it's funny. That was my first thing. It's not so much the First Amendment, even though I think they run afoul of it, but it's definitely the right concerted activity here. So here's what we got. We've got a chief who's an 18-year veteran, female, all right, and she claims that which she did, she maintained a support group for firefighters on Facebook, and there's a policy at the department, and let's get it 100% correct. It says, Kurt, help me out here. I'm looking for the exact words of it. It's like a absolute no, like no social media.
Yeah, here it is. It's about halfway down. It says, IFD social media policy states firefighters shall not engage in social media.
Period. Right? I mean,
right out of the 1950s. Like, what?
Right. You cannot have there is no social media. I mean, people do have the First Amendment right. I think she's right on that, to speak as a private citizen on matters of public concern. So you don't have to engage in the question of whether she was speaking as a private citizen. She's here told you can't speak at all in any capacity. You cannot regulate people's private lives like in this vast way. If they wanted to say, well, you can't do it if your uniform's on, you can't, right? I mean, there's certain possible
things you can do, certainly
things, but this wide swath of you can't make any comment or have any social media because you joined the department. Well, that violates so many.
Remember, the key case in this area is the Pickering case. Okay, Mr. Pickering was a teacher, and he sent a letter to the editor of the local newspaper. Okay. The equivalent of this would be telling teachers you cannot send any letters to the editor.
On any topic at all.
You know, you can't. You can't. You just can't do that. Now, again, this is the allegation. I'm not sure that if we actually looked at the policy, I haven't seen their policy, that there's not some language that kind of backtracks on this or it's taken out of context. But if that sentence is not taken out of context, we got a problem.
Yeah, yeah. It would be very difficult to win without something more in that policy. And there may be. In any event, people may be saying, well, why did this happen? Well, she's told to take the group, down, and she does, but she makes a comment when doing so. She's suspended for only 24 hours. I think people thinking, listen, we got to do something. So they did something to her because I'm guessing the department didn't want to not discipline, seem weak or whatever, but that's what spurred it. And I think people are wrong. So a lot of departments say, well, we're going to do something to you and it won't cause you to sue because it will be so minor. Who's going to sue over a 24-hour suspension? The problem is there are a lot of groups, ACLU and a lot of other groups, who want these lawsuits to make the point that we don't care what you did to her. What you charged her with, your policy is the violation, and it violates someone's civil rights.
I got to believe if the ACLU of Indiana looks at this, they're going to be all over this.
No question. No question. It's too widespread. It applies to hundreds and hundreds of people. It is so vastly, if true, right? Again, please, everybody watching, we don't know what the policy says. We haven't seen it. I'm sure we'll get some emails from somebody in the IFD.
From people, but yeah.
Yeah. But, and if you have it, sure, we'd love to see it. We'd love to comment on it as we armchair, quarterback this. But in any event, she also says she's being retaliated against because of her gender. I think that's a harder, with a policy this vague, I think that, or this broad, I think that's a harder claim to make. It seems like anybody, right, who posts is going to get in trouble. Now, if they're not fairly enforcing the policy, very different issue, right? If three men have a social media group and nothing happens to them, and yet now the fourth person, her, starts a social media group and now something happens, sure, she's got a claim, right? And then she also has the Indiana's Whistleblower Act, and she complained of gender discrimination. This one's a little harder to prove. I don't
understand. I mean, she was accused of violating the Whistleblower Act, which I'm not sure. How do you violate the whistleblower? There's something missing here in the facts here. I don't understand.
I don't know if it was the chain of command portion that tied into it. Like you were supposed to go to the chain of command. I don't know. It's confusing.
I don't know, but yeah, but she's, I'm just looking at it. The IFD accused Ashby of violating the Indiana Whistleblower Act, despite its inapplicability because of her gender. So again, there's a factual question there. I'm a little confused on that.
It's not pled clearly, frankly, but that's a tough one for her to make. I don't know.
Well, she's not accused. She's not claiming protection under
as a whistleblower, correct?
She's claiming she's being disciplined for having violated the Whistleblower Act. So,
yeah, I interpreted that as maybe being related to the chain of command allegation, where they said you violated the chain of command by what you said or who you reported it to. I don't know. It's a little tough, but she stands pretty firm, if the allegations are true, on saying the policy is unconstitutional.
Yeah. Yeah, I think the First Amendment and what we call a prior restraint is going to carry the day right there.
Yep. And I got to tell you, this is in about a month ago, we covered First Amendment cases and we said, listen, there's policies that are by their words unconstitutional and intentionally so. And then there are other policies as applied, nobody ever thought of how you apply it, and yet it does restrain rights or violates rights as applied, even though it wasn't intentional to discriminate that way. This is the first one. This is just blatantly unconstitutional.
I'm actually looking at developing a little theme in one of my classes on the 5 policy provisions you absolutely do not want to have in a social media policy. Ooh, and this one was so obvious I didn't even include it. So now I got to go to 6. Firefighters shall not. You can't prohibit people from engaging in social media. That's
no way. Too broad. I do think, or what do you think? What if they said you cannot participate in social media
while on duty? while on duty.
Well, of course, while on duty, right? And obviously we have constitutional and all, or constitutional, we have confidentiality things you could say. But what about they say you cannot engage in social media at all, having nothing to do with department, if you have your uniform on, or if your whole Facebook page is decorated with you as a firefighter?
The way I incorporate into our policies and the way I do it for my clients is basically you cannot use social media in a way that you're portraying yourself to be a spokesperson for the fire department.
Right.
Okay.
And that's what they should have added.
And that's what because I think by characterizing that as spokesperson, you need a definition of a spokesperson, but by saying that you can't hold yourself out to the public as a spokesperson for the fire department, that the total number of pictures or the total information that you need on your Facebook page
your
is
title on LinkedIn, firefighter at.
Yeah, but just don't hold yourself out as a spokesperson. You can say that you're a member of the department, right? Just like, a fire department can't prohibit you from putting your employment history on your resume. You can't tell people, you
Right.
can't say, you can't say you're a member of this department. Okay, that's gonna interfere with your basic rights there. But certainly you can tell someone, don't hold yourself out to the public as a spokesperson unless you're duly authorized.
And I'll tell you, I have in one of the ways I draft social media policies for clients is I say, listen, what we're going to require something, we're not going to prohibit something. So instead of prohibiting, saying you can't talk about the fire department, I do it another way. What I say is, anytime you speak about anything that remotely has to do with the fire department, you must post, I am not speaking as a member or representative of the fire department. All my views are personal and do not reflect my position at all. And then when they forget to put that, then you discipline them for what they didn't say, they failed to disclaim. And it goes even better, go back to Pickering, where if you speak as an employee, you're not protected, since they did not put that they are speaking as a private individual, having nothing to do with the fire department. The assumption now is you're speaking as an employee, no protected rights. That's how I like to sneak it in.
That's a pro-management approach. I don't know. I gotta digest that one. I think I might take issue on that. Yeah.
Okay.
Listen,
I think you should take this
approach,
next one. This next one in Illinois, if you're in a union, pay attention now. This is a big deal, I think. And I got to tell you, I had this argument when I was fire chief. And the union and me and the village all worked out about shift trades. And I got very nervous. The union was signing off. I'm like, this affects wage and hours, conditions of employment. I kept saying, how is this not a mandatory subject of negotiation? So Kurt, why don't you take this? This is great.
Yeah, no, it's an interesting case. But what we had was, it started with a lieutenant submitted for a shift trade request, and there was going to be a firefighter who was going to cover his shift, and it was on Christmas in 2018. At the time, the department didn't have a written policy on it, but they had a practice, and basically, as long as the battalion chief approved of it, it was no problem. So when the fire chief found out about the fact that a firefighter was going to be subbing for a lieutenant, he instructed the battalion chief to cancel the trade. And in addition, I guess that caused the chief to kind of start looking at this, and said from here out, only people who are the only people who are qualified to trade shifts with lieutenants, I guess, are going to be either lieutenants or people who are on the promotional list. So now the opportunities for lieutenants to get subs was diminished. In addition, he also decided, this wasn't relevant to the lieutenant's claim, but the chief also decided that non-paramedic firefighters could no longer trade with paramedics, which now affects even a bigger group. So. Right. The union filed a grievance over that, which arguably, like a lot of things, it could be a grievance. So they're alleging that it's a violation of the collective bargaining agreement. But I think when the union started thinking about it, when management changes a mandatory subject, it could violate the collective bargaining agreement. It can also be, excuse me, it can also be an unfair labor practice. Now, this is in states that have collective bargaining for firefighters, but an unfair labor practice is a pretty serious charge and has to go to the state labor board. So, bottom line is that is the route that they pursued, and the state labor board agreed that this was a mandatory subject for bargaining. And they appealed it to the, I guess, to the
Whatever
Court
the
of
first
Commons,
level is.
probably. It's one of I'm not sure what they call the trial court, but at any rate, it ends up going up to the Illinois Court of Appeals, and they agreed that this is a mandatory subject, that the city cannot just unilaterally change the parameters around substitutions.
Right.
So, and again, outside of Illinois, I'm not sure how important it is, but certainly within Illinois, now this kind of makes this issue a mandatory subject.
And of course it was, right? To me, like, of course it is. It affects on so many levels, right? It affects your vacation time. It affects your pay. It affects staffing. It affects so
Yeah.
many different things.
This is substitutions for firefighters is such an important thing. I was able to go to law school because of substitutions. It's really the only way I was able to go to law school. So, and I think a lot of firefighters leverage it for a lot of different reasons, not the least of which is childcare and some of the other things. I use it extensively when I'm coaching my sons in Little League and Babe Ruth and right on through the things that their activities. So, the problem is, I don't think there's another profession out there that uses substitutions the way we do. And certainly in the private industry, there is no such thing as substitutions. Yeah, and this creates a problem when people come from private industry and then become either finance people for local government or HR for local government, that they don't understand the impact that working 24/7 can have on people's family lives and other things. So again, this is kind of a unique cultural aspect to the fire service, and the court is basically saying, look, you've got to bargain it. It's pretty clearly within wages, hours, and other terms and conditions of employment.
Yep. Yep. So we caution our fire chiefs, right, out there, that be very careful. You think you're doing something nice, or you're following a unwritten policy, and then you change an unwritten policy, right?
Mhm.
Now you are, it's still,
Right. Yeah, and this decision says nothing about whether or not the chief was ultimately right on the issue. Because if I'm the
right,
chief, I don't
right.
want somebody who's like a brand new firefighter filling in for a lieutenant. I want
Or an
somebody who's
EMT filling in
capable.
for a paramedic,
Right,
right?
right. So this doesn't have anything to do with the rightness or the wrongness of the issue. It has to do with the way in which it's done. And I was going through the notes here. It does look like they did have a written policy, but it wasn't part of the collective bargaining agreement. So the
Oh,
city
okay.
was changing that policy.
And
So
look, past practices can be binding, as we know, right?
yeah.
And this is the way we've always done it. It wasn't in the
Well,
CBA, but it's the way
it
we've
gets
always done it. So
complicated.
you
It gets
can't just change it.
complicated. A very good friend of mine, terrific management attorney, terrific, really kind of took me under his wing when I first passed the bar. We're on the Rhode Island Labor Law Committee, the Rhode Island Bar Association Labor Law Committee, pro management guy. But he doesn't believe there is such a thing as past practice. Okay. And he argues that through the language of the management rights clause that's in the collective bargaining agreement. And the management rights clause basically a well-written management rights clause says, if it's not in the contract, there is no right to it. And we reserve the right to change anything that's not in it. So he will, in a case like this, he would have been arguing the management rights clause.
If it existed.
And it's also called the zipper clause, but basically, if it's not in the agreement, you don't have a right to it, and we reserve the right to make those kinds of decisions. So I think of him quite a bit when I read a case like this. But
Yep.
yeah.
Okay, our last one, I think is such a good, this is what you need to do to protect yourself type of case. So first, we kind of have the holding, and it's a little confusing, but the holding's simple. We have a New Jersey court, appeals court, and ruled that an Asian American firefighter who unquestionably was harassed on one occasion by a ranking officer was not subject to a hostile work environment, right? And that's interesting, right? So basically what they're first stating is one improper harassing event does not mean it's a hostile work environment. And part of that's because hostile work has to be so pervasive throughout the organization.
Severe or pervasive.
Yep. Right. So one incident in this case doesn't do it. Now, by the way, if this was sexual harassment, different story. Please don't relate this, right? You can be sexually harassed on one occasion. You may lose on a hostile work claim.
It's got to be severe, though. It would
got to be severe and pervasive, unless you're in New York State.
Yeah, it's got to involve some really, for one occasion, it's got to really involve some improper conduct.
Right. And look, that's whether you win or lose on a hostile work environment claim. You don't need that if you've been discriminated against, right? Or harassed. You may win on the discrimination end. So there's all sorts of things. But here are the basic facts. We're back in 2020 COVID time. And
you said the word. You said the word.
Oh, yeah, I can't say that right. CO19.
Palomino.
Sorry, yeah, I know. Jesus. Sorry, YouTube. So plaintiff and the other firefighters attended a training on that disease from 2020 that we're not allowed to say. It was presented by, I think, the ranking officer. Plaintiff was tired during the training and fell asleep for a moment. The ranking officer approached the plaintiff, squinted his eyes to parody stereotypical Asian facial features. I have a hard time with that. And asked plaintiff if they had just returned from Wuhan. That's the problem right there. Not so much the first part. And then 19 firefighters witnessed the incident. Now, if they were all laughing, right, or all participated or made later comments, we might have had a different story. But that's where it kind of ends. So the plaintiff, Asian American, complains to the union, and that was brought forward to the fire chief. The matter was investigated, and there would be everyone agreed, or the ranking officer agreed, we'll have no further contact. So the plaintiff, the fire chief, the union, deputy chief operations all got together. The chief was told he would be disciplined, and he went on a terminal leave. I hate that term, but a terminal leave until there is retirement. That's a nice way of saying we're going to pay you just to not be here and cause any more problems. Never came back to active duty, and he never then underwent any discipline. But I would argue he kind of was. It's still discipline to say you can't be here anymore.
I'm not sure they said that, though. I'm not sure. And again, the decision wasn't real clear on that, so I didn't want to speculate. But I think if the chief immediately after it happened, once he went under investigation, just went on leave on his own, I think that's probably more likely. If the chief told him, don't come to work anymore, that's a different story as well.
Right. So, okay. So there would be no discipline if it was his choice. And I don't think anybody should be able to escape just because, okay, I'm on leave now. You don't get to escape discipline, right? And maybe delayed.
What's the point of giving somebody a reprimand after they've retired? Can you do it? Yeah. But and I think the court kind of got into that. The court said, the point of the employer is to act reasonably in response to an allegation. And we feel the department did that.
Yeah. So, and the main thing the court emphasizes is right at the beginning, and this is, I say this all the time to people, let's say it again now. And this is your three-legged stool. You need, as an organization, the court focused on this in the first, right at the beginning. The court states that the department had an effective anti-discrimination policy, not just an anti-discrimination policy, an effective one. And they enforced the policy promptly. And on that basis, the trial court, now affirmed, dismissed the case. But see how important that is. Everybody has to pay attention. If you have an effective anti-harassment policy and you follow it, I would add one more thing. I always say you have the policy and you train on the policy. This is right, 2 out of 3 of your stool. Obviously, you got to enforce it. But whenever there's an allegation, let's remind people it can be training. Maybe it's a minute of training or it's an hour of training, whatever we need to enforce it. You have to remind people we have a policy. And even though we're not saying this happened or not, this is not allowed. This conduct is not allowed. And I know people say to me all the time, well, What if it was private? What if nobody knew it happened? Well, that's not the facts here. Here it happened in front of a whole bunch of people. Everybody should be reminded this is not acceptable, right? And
what
you
happens
can't
in
do it in
real
the future.
life? What happens in real life is the front office has all these problems going on. They get this going, they get that. The mayor wants this, the council wants this, and you're getting sued here, you're getting sued there. You get all this. Now all of a sudden you have a thing like this, and the department, the front office goes into defense mode. And they're trying to circle the wagons, and so they actually debate whether or not we should investigate this. Should we do? And that's not what this department did. They immediately started the investigation. They immediately assured the firefighter that they wouldn't have any further contact with them, and they did it right. And we got to get out of that circle the wagon mindset. And I think lawyers are sometimes responsible for putting so much fear in chiefs that they don't understand their obligation to investigate these things and not kind of sweep them under the rug or hope they're going to go away so they can get back to their other problems of the day. That's what led to this fire department winning this lawsuit.
And I got to tell you, I have a case in front of OSHA now where somebody is claiming they were treated in violation of the workplace violence policy. And even though we don't think they did, what we did immediately is exactly that. We reminded everybody about the workplace violence policy. We investigated to determine whether it was a valid complaint or not. But even though we found the complaint to be not valid, we still did some training to ensure that everybody understood the workplace violence policy. So investigation, enforcement, maintaining the policy matters more than anybody else thinks. A policy book on the shelf that's collecting dust is not enforcement. And, I hate to say it, but I don't hate to say it, just to keep pushing and selling, Kurt's in my program about must-have policies that, we could do a policy book for you and say, here's 500 policies, you're done. But that's not effective. That gives you words on the shelf. When you get like what we're doing for people who haven't yet heard, we send out 3 or 4 policies a month with videos so they can be implemented in order, right? And methodically, and you can enforce them. You can train people on them. You can customize them, all of these things. You can't just have words on a shelf. If you are not reviewing your policies, both internally every year or so, and you should have a list, as we do. We should have a list of which ones get reviewed each year. And if you're not training your employees on every single anti-harassment, anti-discrimination, whatever prohibited code of conduct is, right? Your code of conduct, if you're not training people on what conduct is allowed and expected and not allowed, you're missing the first leg of that chair, right? Or a second leg, I guess, right? Is training. You've got to have training. So we think the way we're sending out policies is advantageous to many, right? Many departments. But for all of you, please, if you've got books just saying we have policies, that will hurt you if you're not training on them and enforcing them.
Yeah. I think this is a great case,
Great case.
a great example of how to do it right. Unfortunately here, we often cover, problems where departments didn't handle it right. This is a victory, and not to diminish what this firefighter went through. I'm not trashing on the firefighter, but this is an example of a department that handled it properly, and the court recognized that.
Right. And look, one screw up doesn't always mean you're guilty, right? In the harassment, in the discrimination, right? Certainly in the hostile workplace environment, you can't have an environment full of hostility if you're diffusing it, if you're taking proactive, immediate, fast steps to say this conduct is not tolerated, we're not doing it. In this case, they said, well, you didn't, do anything for all the people. You didn't reprimand, right? There's a whole bunch of people who were observing in the class. That's not what makes it pervasive and severe, right? But if you need to show that somebody went back to the classroom and said, guys, this is not acceptable. Now, that's hard when the chief is there, but it's not hard once he's on leave or in another world, disciplined or whatever. So it's training, enforcement, two legs out of the stool. And if you have them, again, you can win. If you take immediate action.
Right? The 3 of them, right? You got to have a policy.
Yep.
You got to have training. You got to have effective supervision. If any of the legs on that stool are weak, the stool is in jeopardy of falling over. Yeah.
Yep. But here, good example, a great case from you to show people this is what you get even if something bad happens, if you have an effective policy and you enforce it, this is the benefit of doing that. It's the hour you save a year, 2 hours a year in training your employees about effective conduct will save you thousands of hours and hundreds of thousands of dollars of litigation costs in the future. Totally worth it.
And don't hesitate to start an investigation.
Right.
Don't feel like you have to circle the wagons. Don't close your eyes and hope that the problem's going to resolve itself. Maybe it will, but do the investigation.
And here, nobody's above the law.
Yeah.
Right? The chief isn't above the law. Somebody's got to be above the chief in that sense. And in a bigger department, that's much easier than a small volunteer department. Small volunteer department, that's hard. That should be maybe the board of directors or board of trustees, who's maybe over the chief, but much easier when you have a bigger department as we do here.
Yeah, you want to make sure, even in a small department with a board of directors, that if they're going to meet once a month, you can't say, well, we're going to wait a month to start an investigation. The chief ought to be authorized to initiate the investigation. There should be a procedure for doing that.
Right. And I'll tell you, I guess as my last comment, I'm a little surprised about the lawsuit, not because I don't understand the anger over the conduct, right? That conduct, if true, which I presume it was, obviously, horribly offensive conduct. But what I'm surprised at is most times, I have no stats on this, but most times you will not see a lawsuit when you convince the employee, we took this seriously, we're taking it seriously, it's not tolerated, we're not going to tolerate it, we've got your back on this. And I think what probably pissed off the employee is what the allegations were. You allowed the chief to take an end-of-term retirement, no harm, no penalty. It's a paid vacation, right? They should be arguing. We're arguing effectively. Yeah. And I get that brings up the anger, right? But this probably was more about, I'm angry because it looks like you let the chief off rather than you had my back. So, but
you filed shortly after, so I'm not sure that the firefighter even fully understood everything that the department had done. And there's a little bit of conflict here with HR because HR feels that discipline is between the employer and the employee, and no one else needs to know about it. Now, they did let him know that he was going to be disciplined, but they didn't get into the specifics of it. And ultimately, it led to probably contributed to him and his decision to retire. So,
Right. Right. Anyway, great case. A number of great cases. Unions, individuals, departments. Great case. Great case.
Social media.
Yep. Social media.
Good week. The best. Good week. All right. Well, that's going to do it for another edition of Fire Law Roundup. Brad, we'll see you again next week.
Have a great one, everyone.
Folks, if you haven't subscribed, please subscribe. Please click like and help us keep doing what we like doing.
And see